Good afternoon. I'm Sarah Richmond. I'm a member of Schoeneck King here in the Westchester office. I'm a member of the School of Law Group. I want to introduce my co-presenter, Mariam Qureshi. Mariam?
Good afternoon. This is Miriam Qureshi. I'm a senior counsel at Bond Schoeneck and King in the White Plains office, and I am also part of the law school practice group.
So we're going to get right to it. So this topic is about the relationship between the New York City DOE and private schools, and there's a lot of interplay between the two. As an introduction, this is very basic, and I know most of you are familiar with these terms, but just to ensure, the New York City DOE is the local public school authority for New York City. Non-public schools are the terms for all private, independent, and religious schools. So that's sort of the umbrella for all of them. Does not include charter schools and public school districts as well. And the Office of Non-Public and Charter Schools is a specific New York City DOE office that manages this relationship. Okay. Next slide, please. So what we're going to be talking about generally is the relationship between these two organizations, because there are a lot of codependencies between the New York City Department of Education and independent schools. The New York City Department of Education serves as a local educational agency for all students attending non-public schools within the parameters of New York City. This is particularly relevant in the context of special education, but also provides funding in specific circumstances for tuition for special education students, and also provides all different benefits or funding sources and streams and supports for independent schools as well. There are approximately 30% of the New York City students attend private, parochial, or independent schools, and the DOE coordinates services and supports for these students, even when they're outside the public school system. So there are certain appropriate educational supports to meet students' needs that New York City resident students are entitled to, even if they do not attend public schools within the city of New York. Next slide, please. So the purpose and impact of this relationship is that it ensures equitable access to services and supports for all students, whether they attend private or public or non-public schools. And there are certain funding requirements for special education students, for English language learners, for textbooks, and some other things that we'll discuss later, that the New York City Department of Education is responsible for coordinating with the private schools. The New York City Department of Education is also responsible for creating individualized education programs, IEPs, for students, whether they attend public or non-public schools within New York City. Okay. The shared goal of the DOE and, of course, the private schools is to make sure that all students receive appropriate educational supports to meet their needs. Next slide, please. Okay. So the first thing to talk about is substantial equivalency, and this has been in the news a lot lately because there have been some updates to the substantial equivalency regulations, where this is actually going to be the subject of a presentation a little later in this series, where we're really going to talk about this. A lot of these substantial equivalency regulations were addressed and arose out of some concerns with some parochial schools, yeshivas, and some other schools in New York City, but do attach to all, the requirements do attach to all non-public schools. So what New York State Education Law Section 3204 requires is that all students in New York State, and that includes in New York City, receive an education that is substantially equivalent to that provided in the public schools. As I said, it applies to all non-public schools, including independent, parochial, and other private institutions. So there are certain basic literacy or basic standards that have to be met in English language, arts and literacy, mathematics, science and social studies, civics, physical education, health, and other core subjects. But it's important to know that the goal is not to standardize curriculum, because so much of what makes the independent schools or the non-public schools unique in New York City or and across the state is their unique curriculum and the way that they approach education. But rather, it's to ensure that non-public school students receive an education that prepares them for civic engagement, further education, and economic self-sufficiency overall. Okay, next slide. So as far as substantial equivalency, the Department of Education has a regulatory role. Outside of New York City, the local lead educational agencies, the public school districts, where other private schools are located, also have the same regulatory role, where they are required to conduct local reviews in the non-public schools which are located within the city. Their reviews are guided by the New York State Education Department regulations. So the new DOE conducts a local review process and then submits a recommendation to the state education department about whether a school meets the substantial equivalency requirements. Next slide. Substantial equivalency, as I said, is not designed to interfere with religious instruction or school philosophy. You still, as a non-public school, retain curricular autonomy, traditions, and cultural identity, but you have to, the DOE will work with you to support compliance while respecting your distinct mission. And that's something that is built into the regulations and into the whole review process. This is more of a broad strokes in terms of meeting certain threshold requirements in terms of substantial equivalency of education, but it, as we said, or as I said earlier, does not, should not be impacting your curriculum or your mission. Next. Okay. Another role that the DOE plays is that it is a service provider role. It provides equitable access to funds. So the DOE, through the Office of Non-Public Schools, facilitates access to state and federal programs that provide certain publicly funded resources to students enrolled in non-public schools. Services go, but the thing to remember is that the services go to the student, not to the private school themselves, and have to be secular, neutral, non-ideological as required by state and federal law. Next slide. So these are some of the key services coordinated by the New York City DOE and some of the funding that private schools are entitled to as part of the allocation for each individual students who attend their schools. They have access to New York State's textbook loan program, which provides textbooks, library books, and equipment. Those materials remain owned by the DOE, but are loaned to students for this use. This is not to say that you have to use books that are part of the New York City DOE curriculum, but there are certain forms and processes that have to be followed in order to access that program. And that's something that is available, the information about it on the DOE website, also on the state ed website. But that'll show you how you go about the process of applying for those books. But that is something that students who attend public schools, private schools, are entitled to. Private school students are also entitled to transportation services as long as they are eligible, where they are eligible, and they can get Metro cards, special busing for students with IEPs who require special busing, Metro cards depending on their amount of their commute, and it is consistent with that is applied to, that is available to students of public schools. Next slide, please. The DOE also coordinates the services under the federal titles, educational titles. So Title I is federal funding for low-income students who are academically at risk. So those funds, Title I funds, are available to private school students as well as public school students. Professional development services for teachers in non-public schools delivered by DOE selected vendors, but professional development services to help with teacher development and curriculum development. Title III relates to English language acquisition services for students who are multilingual learners or English language learners, so they too are entitled to funds. And Title IV, which provides enrichment programs supporting well-rounded education, safe, healthy learning environments, and effective use of technology. So as I stated earlier, all this money flows through the Department of Education in New York City and flows to the individual students related to the amount of students you have who are entitled to these funds under any one of these federal laws. Next slide. Okay, so the federal services must be supplemental. They don't replace the school's core program. Again, they have to be secular, neutral, and non-ideological. They have to be equitable compared to services offered to public school students. And that works both ways. If certain public school students are getting certain benefits or certain services, those services should be available to independent school students or private school students as well. Again, remember that the services are provided to the students, not to support or enhance the private school operations. Okay? The DOE is also required to ensure compliance with federal and state requirements, including equitable participation, documentation and accountability, and vendor management for service delivery. So that's something that the DOE is required to ensure that private schools are complying with. And they should collaborate with the non-public schools to ensure that families are getting the supports they are entitled to. And that can be medical services, special education services, textbooks, other supports, ELL services. Next slide. Okay, at this point, I am going to turn it over to Mariam, who will be speaking more about special education.
Hello, everyone, again. So special education and student support, there's been a lot of changes recently. And by recently, I would say over the last like 2 or 3 years, where a lot of private school cases are going to hearing. This is definitely a big change in the trend with this new administration, Eric Adams' administration, not so new anymore, but with the de Blasio administration, most of the cases that were filed by parents of students with disabilities seeking tuition funding for private schools were settled. And over the last few years, it appears that DOE is pretty much, taking most of the cases to impartial hearings. So this is an overview of what the current DOE trends are. As I said, there's an increasing movement towards doing impartial hearings, full impartial hearings, not just pendency hearings, which all of you are familiar with, and more adversarial stance towards handling these cases. Also, the DOE is engaging in a lot more scrutiny of the documentation, testimony, and the practices of the private schools curriculum, private school curriculum, which kind of goes hand in hand with what Sarah previously mentioned about substantial equivalency. That's kind of where things started out with, because the DOE was taking the position, and the state sort of aligned with the DOE that, not every private school curriculum was meeting the substantial equivalency requirements. So that's something the DOE is scrutinizing. Similarly, with respect to, and this impacts more the religious schools. And then similarly with respect to student, the school day, how, what extent of education is being provided, and so on and so forth. There's definitely a lot of shifting expectations as it concerns private schools. So, how do the private schools prepare for these changing trends? A lot of, the private schools must be very proactive with their witness testimony. I understand that a lot of witness testimony is being done by affidavit preparation, but that's where a lot of preparation and involvement is required. You should have very strong detailed documentation on student progress. There should be an active participation in the IEP processes and communication with families, because that's really where everything starts. It precedes the actual impartial hearing. And then in preparing for the shifting policies and administrative changes, obviously, as we know, each administration comes with its own set of goals. The de Blasio administration, when they started, I was at the DOE at that time, and the directive was to try and settle most cases because the administration felt that students with disabilities, parents of students with disabilities, have a lot going on in their lives, and so it would be, if we could try and settle a case, the scrutiny could shift more towards settlements, and we move forward with that. However, it sounds like the Eric Adams administration, which I'm no longer a part of that administration, at the DOE, things have shifted a little bit more, and it's more towards scrutinizing cases more deeply. we now have a new administration coming in next year. And so, the schools should be ready to pivot and change depending on what the goals of the new administration are going to be. So, next slide, please. So the current DOE trends, as I previously mentioned, DOE is increasingly moving towards pursuing impartial hearings in the vast majority of the tuition reimbursement and payment cases. Previously, most of the cases were settled. This is no longer the norm, and DOE attorneys are aggressively challenging and are requiring more stronger evidence and clearer testimony. Also, the DOE seems to have broadened and increased their attorney presence. Previously there was also the trend that the CSC people would appear and like litigate cases against private school attorneys, but that's no longer true. It appears that most, if not all, the cases are being handled by DOE attorneys. A lot of these attorneys are also not even based in New York. So people are like coming in with like different lens. I think the general understanding is that there's a lot of scrutiny that's going to go in into all of these cases. So they're challenging the records more aggressively. It also appears now that the hearing officers are taking a much more in-depth view and in-depth analysis of the cases coming before them for impartial hearings. In a lot of cases, my understanding is that the hearing officers are actually questioning witnesses and asking for information which the DOE attorneys might not even necessarily be asking for. So with that, you really have to be prepared to deal with these shifting trends. Also, a big shift has come from the fact that previously the impartial hearings were handled by the hearing officers that were hired by the state education department and were part of the DOE's office, impartial hearing office, though not reporting to DOE. Now, all these impartial hearings are handled by the Office of Administrative and Trials Hearings Unit, the Oath Agency, which is a city agency. And a lot of these hearing officers who are attorneys are not necessarily special education attorneys. And therefore, their understanding at times is coming from questioning the witnesses and questioning the information in the affidavits at the time of the hearing. So the schools must be ready well before a case is filed. Next slide, please. So how do we, support the students and strengthen the school's position? What are the best practices? The first and foremost one being witness preparation and staff coverage. A lot of the schools have identified one individual as being their prime witness who prepares the affidavit or, reviews the affidavit that is prepared by parents' council and then signs off. And if those affidavits are if they're called to testify for cross-examination, we have this one individual. However, best practice would be from the very start to appoint more than one person who would be a witness. The reason is that, sometimes if you're relying on just one individual and someone gets sick or is not able to participate for whatever reason, then schools are stuck at the last minute scrambling and trying to prepare someone else to, take over. And these are not easy proceedings to go into. They can be adversarial, so it's best to ensure that all witnesses are well prepared ahead of time. Also, early preparation reduces any kind of last minute errors and it supports with consistent testimony. The other really important thing is for the witnesses and the staff to understand the student's program. In most cases, the witnesses are not necessarily the teachers of the student or someone who works directly for the student with the student. And it is someone at the school probably at a higher position or a different position other than the individual who is working closely with the student. And therefore, they're relying on the information provided by the student's teachers or service providers. And so if they're a step removed from the actual information, so it's extremely important that whoever the witness is designated at the school as the individual who will be testifying has a very clear understanding of not only what the school can generally provide, but how the school addresses the unique needs of the student and the program that it provides to the student. How, what are the challenges that the student was facing when they first started at the school? How did the student develop over the course of this school year? What progress the student has made? Well prepared testimony reinforces the school's credibility. Next slide, please. So, continuing with the best practices to support students and strengthening the school's positioning, affidavits, accuracy, and risk management. I understand that most of these affidavits are prepared by parents' attorneys. However, and please understand that you are the signatory to these affidavits. So it's extremely important that you review these affidavits, whoever is signing off on them, and be very familiar with all the information that's in the affidavit. Because at the end of the day, note that these affidavits that are going in lieu of direct testimony are going in with the understanding that if there is any question, the witness whose affidavit this is going to be available for cross-examination by the opposing counsel. So make sure that you carefully review the affidavit, make sure that you are in agreement with all the information that if there's anything that you're not sure about or you believe that needs clarification, don't feel shy to go back to parents council. Yes, they're doing this work on a daily basis. Yes, they're very familiar and very thorough and accurate, but nonetheless, it is your affidavit to sign off on. A lot of these affidavits are now also going on to cross-examination. So witnesses are being called on cross-examination, and the hearing officers are increasingly, reviewing the inconsistencies or talking about any missing details or contradictions that are showing up. And if there is, in fact, any inconsistency or any missing detail between the testimony at cross-examination and the affidavit, that obviously undermines the school's credibility. So again, I cannot emphasize more. If something in the affidavit does not match your understanding, please consult with your parents' counsel, request revision, speak to the individuals at the school who have provided you this information, as you're playing a very critical and central role in establishing a strong record. Next slide, please. As I mentioned earlier, any preparation for the impartial hearing begins way before the actual hearing. Strong documentation equals strong testimony. A lot of these hearings now, it appears that the DOE is asking to conduct the impartial, before the hearings, a lot of these CSC IEP meetings, it appears the DOE is returning to phone-based IEP meetings. Whenever possible, please make sure that you request that the DOE participates by Zoom. This enables you to identify everyone who's actually in attendance at the IEP meeting. It also ensures that the meeting record is being accurately kept. And it provides for stronger evidence if the IEP is later scrutinized at the hearing. Why is this important? It's important because IEP is one of the fundamental issues at hearing. It's the IEP and the placement offered by the DOE that's under scrutiny at these impartial hearings, because when the parents are signing and placing their child in private schools, they're essentially rejecting the IEP and the program recommended by the DOE at the IEP meeting. Hence, it's extremely important that the private schools participate in these meetings and ask for a Zoom meeting, because it's always easier to clarify any concerns or questions when you are in a Zoom meeting rather than, having someone be on the phone. DOE's litigation posture, again, as I said, DOE may fight more cases, but that does not mean that every case that the DOE is fighting is a strong case. Therefore, it's even more important that private schools should maintain a consistent, factual, and well-prepared stance. And remember that any disputes can be resolved at any point prior to the hearing. So if you get a 10-day notice, Don't automatically assume that it will go to hearing. I understand DOE is pushing more and more, but it doesn't mean that a case cannot settle. Hence, the stronger your case, the better it is for the private school as well as for the parents. Next slide, please. So, another thing that recently came to attention was the introduction to the IDEA consultation process. DOE has been reaching out to private schools via notice and a letter asking private schools to gather information about parentally placed students. These are students whose parents are not suing the DOE for tuition reimbursement, but are just seeking equitable services. This is more applicable for parochial and religious schools. And then the other is the information about students with IEPs whose parents are seeking tuition reimbursement. This process increases DOE's outreach and places new administrative responsibilities on the private schools. Um, as I said, the process starts with DOE sending out a letter to the private schools and asking that the schools notify the families of the consultation process so the parents understand that the private schools are providing information about their children. The DOE in its letter states this that the private schools should post the DOE issued parent notice in a prominent and a clearly visible location. It's extremely important that you inform parents prior to sharing any information or specific information about their child. If you're in doubt, please consult with your school attorney before providing any sensitive information or responding to any request that is not clear to you. This is extremely important because this impacts the confidentiality of student information that you're about to share. This is not information that you should be discussing with parents, attorney who are representing the children at these impartial hearings because that would present a conflict. This is information that you need to discuss with your school attorney. Remember, proper handling of the consultation process protects both students and the private school. Next slide, please. So this brings us to the conclusion of our program. If you have any questions, you can always feel free to reach out to Sarah or me, and or if you have your school attorneys, you can reach out to them and consult them with any questions.